diligently to secure additional panelists, and while scheduling challenges remain, we are still moving forward tonight, and so we really appreciate your participation. Our mission is to provide educational information to our community, and this is a very timely topic because these proposed constitutional amendments coming up, this one in particular, will likely end up on the ballot this year. So this is voter information, and I hope you will share what you learned tonight also. We will be providing this via Facebook Live on our Facebook page. Please join us there if you haven't, Virginia Committee 100. And without further ado, let me introduce our moderator. Donald Koshin is Professor of Law at the Antonin Scalia Law School of George Mason University, where he teaches state constitutional law, among other courses. He is an elected member of the American Law Institute and a non-resident scholar at the Center of the Constitution of Georgetown University Law Center, where he was a visiting scholar in residence during fall of 2018. His forthcoming book, Framing the Constitution, The Impact of Labels on Constitutional Interpretation, is slated for publication by Cambridge University Press. We are very lucky to have him here with us this evening, and I hope you'll give a little round of applause.
Great, well thank you very much. Thank you to Lynn and to Denny and to the entire organizing leadership for inviting me for this program. If at any point anyone cannot hear me, please do raise your hand and let me know. I know we have the mics here, but I'm also I'm not immediately against it. This is an honor for me to be able to moderate this. As mentioned, I do teach state constitutional law, so I'm interested in the process-oriented issues of this. I'm not a subject matter expert, so I'm excited to learn from our subject matter experts tonight, and I'll be introducing them in just a moment. The idea of having a civic association discuss important issues was what really intrigued me about this. So I'm also excited to hear and learn from all of you and the questions that you will be posing to the panelists tonight. I will give some further instructions about your role in contributing to the discussion after we hear from each of our panelists. As you know, they will each speak for 12 minutes, then have a couple minutes to respond to each other before we open it up to all of you. Before I turn it over to our panelists, I was asked to give a couple quick remarks about the nature of the Virginia constitutional process and constitutional amendment process. So I'll start there before I give the intros to each of our panelists. Many of you are probably better experts on this as Virginians than even I am, and many of you may already know this, so I apologize for what you do know about the process. But ultimately, the procedure for what we are, for the amendment that's going to be discussed tonight in our program, which is, as you know, titled the Proposed Virginia Reproductive Freedom Constitutional Amendment, follows what is set out in Article 12 of the Virginia Constitution. And as you know, there is a process in the Virginia Constitution which requires that there be a 2-assembly plus ballot measure approval process. And that requires then that the amendment be adopted by the Assembly in their first regular session, and then held after the next, in their General Assembly session. And then the first general session in the next General Assembly must pass the same amendment by the same text. And then it must be presented to the voters for a ballot initiative resolution. I think that this is a fascinating process, and I think engaging in it is one way that identifies some of the important procedural ways that rights are protected in constitutional law. And it really is a brilliant innovation to require this multi-stage process to ensure that there is adequate deliberation on this, and to ensure that there is not the kind of interest group capture that might come in any constitutional amendment process if there were not these additional checks. As a law and economics scholar, and someone who, one of the things I do at the law school is run the Law and Economics Center at George Mason Scalia Law School, we often talk about constitutional laws from an economic perspective. One of the things that we then describe is the matter and methods of changing law and what I call in some of my scholarship cost-enhancing rules. That is, the things that make it very costly and difficult to change the Constitution are designed to make it less frequent that such things occur. Because if something is cheaper, you get more of it. If something's cheaper, you buy more of it, right? And so if something's more expensive, you deliberate longer, you think longer, and it also makes it more expensive for any particular majority to capture the constitutional amendment process. So these kinds of cost-enhancing rules are very important from a law and economics perspective, as well as just from a constitutional law perspective. And adhering to them is one of the brilliant ways in which constitutional law at both the federal and state level have ensured that the Constitution will always have, both the federal and state Constitution, will have a special place in legal governance that is separate and apart from general legislation, because it's harder to change and it's harder to get new amendments introduced. Will we see that happen this time around? And if we do, what might the consequences be? And for that, I'm going to turn it over to the subject matter experts. And we have two excellent panelists to guide us through that discussion. And first up is going to be Susan Muscat. Susan is an attorney and a longtime veteran of the pro-life movement. She has extensive experience in analyzing issues of political and legal environment, and lobbying and providing legislative testimony on behalf of pro-life and pro-family legislation at the federal and state level. She's lobbied many years before the U.S. Congress as well as the Virginia Assembly for groups such as in positions such as the Senior Legislative Council for the National Right to Life Committee, and as president of the Pro-Family Women. Ms. Muscat graduated with honors from Georgetown University, and she received her JD from Notre Dame Law School. Ken Cuccinelli served in the Virginia Senate for 8 years before serving as Virginia's 46th Attorney General. And in Ken's words, not mine, but I was glad to hear them, he is a proud graduate of the Ensign and Scalia Law School at George Mason University. And I will say that we are proud to have him as one of our alums as well. He began practicing law, including constitutional law, over 30 years ago, and will be providing us with some of his expertise in that field. So with that, I'm going to turn it over to Susan to get the conversation started.
Thank you very much. And thank you to all of you. I'm very happy to be here tonight, and I appreciate the opportunity to come and speak with you about this Reproductive Freedom Amendment to the Virginia Constitution. Now, this proposed amendment would allow virtually unlimited abortion at every stage of pregnancy. It's expected to be voted on in the opening days of the Virginia General Assembly, which will open next Wednesday. And assuming it passes, it could then be on the ballot for voters to vote on as early as this April. So it will either be voted on this April or during the next November election. To begin with, I want to be clear that contrary to what Governor Spanberger said during the debate, this amendment will not merely return things to how they were prior to the Dobbs decision with regards to Virginia statutory law. It will not simply codify Roe. The language of this proposed amendment gives far greater protections to the woman's right to abortion than Roe or its progeny ever did. And this is not just me saying this. Similar state constitutional amendments have been passed in other states and have been used to block state pro-life laws that were valid under Roe and its progeny. To begin with, courts that have reviewed similar amendments in states like Ohio and Michigan have said that it is the language of the amendment that is the controlling standard. For instance, in Ohio, a common pleas judge wrote that, quote, the plain language of the amendment clearly sets forth the applicable legal standard, and that, quote, defendant's argument that the pre-Dobbs standard is applicable is unpersuasive. A second judge in Ohio, this time in Hamilton County, rejected the state's assertion that the pre-Dobbs legal standard applied, and instead concluded that, quote, the amendment's language plainly establishes that it offers greater protection of individuals' rights to make their own reproductive choices than those adopted by the U.S. Supreme Court in Roe and Casey. And similarly, a judge in Michigan took the same position. So the judges are looking to the exact wording of the amendment, and these constitutional amendments are worded very broadly. and could be used to overturn state laws that were permissible prior to Dobbs. Laws like Virginia's law requiring parental consent for a minor's abortion and prohibiting tax funding of abortion. Abortions will be allowed up until birth. The full extent of the breadth of these amendments will be fleshed out in the courts. And Virginia's residents will watch helplessly as harmful interpretations of the wording of this amendment are adopted by courts. So I want to begin by giving you some examples of key words and phrases in the amendment and how they are likely to be construed. The actual language of the amendment, HJ1 and SJ1, can be found on the Virginia General Assembly's website. Again, it's HJ1 and SJ1. So first I want to discuss parental consent. If this constitutional amendment is adopted, we can expect that it could be used to overturn Virginia's law currently requiring parental consent before a minor child's abortion. And here's how. At the very beginning of the amendment, it states that every individual has the fundamental right to reproductive freedom. The amendment states that every individual, it doesn't say every adult. It says every individual has a, quote, fundamental right to reproductive freedom. So there are no age restrictions. Minor girls would equally have a fundamental right to reproductive freedom, which the amendment defines to include.
Yours is working, Kathy. Switch up.
Sorry about that. Okay, minor girls would equally have a fundamental right to reproductive freedom, which the amendment defines to include abortion. If proponents didn't want the amendment to apply to minor girls, it could have been drafted to say every adult, but they didn't do that. And when this amendment was debated in the Virginia General Assembly in 2025, the proponents of the amendment did not contest that it could be applied to minors. Now, proponents of the amendment will say that there is no language on the face of the amendment that will overturn Virginia's current parental consent law. But parental rights will suffer death by adjudication as lawsuits are brought in court. The Virginia Constitution supersedes conflicting state statutory law. And if there was any doubt that parental consent for abortion is in the crosshairs of this amendment, it was erased during the Senate floor debate in 2025. During debate, Republican Senator Tara Durant offered an amendment to clarify that the constitutional amendment would not overturn Virginia's parental consent on abortion law. And the amendment clarified that Virginia could, quote, regulate the provision of abortion care and gender-affirming care for minors. Sadly, the amendment was defeated with 19 Republican senators voting for it and 21 Democrat senators voting against it. And so this language could be used to overturn Virginia's law requiring parental consent for abortion because parental consent will be viewed as a burden on the girl's right to abortion, and the amendment specifically prohibits a burden or infringement on the right to abortion. Moreover, under this amendment, any statute on abortion that limits the woman or girl's, quote, autonomous decision-making is invalid. A parental consent law, by its very nature, limits the minor girl's autonomous decision-making, and so will likely be unable to stand under this proposed constitutional amendment. Now, state parental involvement laws have been legal under the pre-Dobbs case law for decades. About half the states have parental involvement laws. But even though Virginia's statute requiring parental consent for abortion was compatible with Roe and his progeny, it could fall under the language of this proposed amendment. But that's not all. It could be used to overturn other parental rights. You see, the word individual includes both female and male, so it applies to minor girls and boys, and they both have a, quote, fundamental right to reproductive freedom. Now, what is reproductive freedom? Well, the amendment gives some examples like abortion and contraception, but ultimately it's going to be whatever a court says it is. Foreseeably, minor children will have the fundamental right to abortion, all forms of contraception, sterilization, and for children experiencing gender dysphoria, sex-rejecting transition procedures without their parents' consent or involvement. Equally egregious, the constitutional amendment will protect those who are, quote, aiding or assisting someone in exercising the reproductive freedom. This language could allow a school counselor to take a minor child for an abortion, contraception, or to undergo gender transition procedures without the child's parents' knowledge or consent. Now, we're all familiar with the recent news reports regarding allegations that a high school official in Fairfax County arranged for an abortion for a minor girl without the knowledge of her parents or guardian. Governor Youngkin has ordered the Virginia State Police to conduct an investigation into these allegations, and the investigation is ongoing. If this proposed amendment becomes part of the Virginia Constitution, its language protecting those who aid or assist an individual accessing an abortion could be used to protect school employees who take minor girls for secret abortions without their parents' knowledge. And we all know how students will often trust what a school employee tells them. The amendment specifically states that, quote, the Commonwealth shall not penalize, prosecute, or otherwise take adverse action against any individual for aiding or assisting another individual in exercising such other individual's right to reproductive freedom. How would you feel as a parent if you found out after the fact, and maybe when a child needs to be taken to an emergency room, or they turn to you as their parent to comfort them in distress, and you find out what they've been through, and you had no idea that an abortion had taken place? Or how would you feel if you became aware that a school employee was taking your son for gender transition procedures without your permission, and the school employee's actions were protected by the Virginia Constitution? Now, I want to shift to another area of grave concern with this amendment, and that involves third trimester abortions. Now, when some of you read the language of the constitutional amendment, you may mistakenly think that it gives the Virginia legislature the power to prohibit abortions in the third trimester, but it doesn't. It has so many loopholes that it leaves the Virginia legislature powerless. So I want to point out the huge loopholes in the language so that our listeners are not misled. The language purports to allow Virginia to prohibit abortions in the third trimester, but then it goes on to say that Virginia may not prohibit an abortion if, quote, in the professional judgment of a physician, and I want to stop there and repeat it, in the professional judgment of a physician. And who is the physician? It's the abortionist. So it leaves it up to the abortionist to decide. And I go on. Virginia may not prohibit a third trimester abortion that, quote, in the professional judgment of a physician, i.e. the abortionist, is medically indicated to protect the life or physical or mental health of the pregnant individual. Mental health is a huge loophole that will encompass anything that an abortionist says it encompasses. So this third trimester abortion provision is a phony provision, and it gives the Virginia legislature no real authority to enact a law to restrict third trimester abortions. So under this amendment, abortions will be allowed up until birth. And lastly, I just want to highlight, I want to return to the point that I made at the beginning, that the amendment gives far greater protections to abortion rights than pre-Dobbs. And I want to make one last point. The pre-Dobbs Supreme Court case law recognized a state's interest in protecting the health of the pregnant woman, protecting fetal life, and protecting the integrity of the medical profession. But with this proposed amendment, outside of the phony third trimester abortion provision that I just discussed, Virginia only has a compelling state interest to regulate abortion if it is for the purpose of regulating the health of the pregnant woman. And even then, and this is key, even then, it cannot infringe on the woman's, quote, autonomous decision-making. Think about that. Any law that the Virginia legislature enacts because it believes it is necessary to protect the health of the individual seeking abortion care could be declared null and void if it infringes on that individual's, quote, autonomous decision-making. And any law that the woman disagrees with will infringe on her autonomous decision-making. Thank you very much.
Great, thank you, Susan. Ken?
So I appreciate Susan's detailed analysis, so I'm going to try not to duplicate what she had to say. For those who I haven't met, I've met many of you before. I will be voting no on this amendment. When I read an opinion piece in a newspaper, I want to know the perspective of the person I'm reading. That is my perspective. But I'm also a constitutional lawyer, and I'd like to try to address the question that I was asked to address, which is it my view that this amendment would take us back to a position where of Roe v. Wade law? That was the question I was asked to answer here tonight, and the answer is no. It goes well beyond Roe v. Wade. And while I'm not the law professor here tonight, I will take you through some quick history. Roe v. Wade, of course, was decided in 1973. At the time, it was considered somewhat of an unusual decision. It created the trimester framework that really had not been argued to the court, and it barred, to a great degree, in its language, most protections from abortion. That meant abortion was legal up to the moment of birth in most instances, or that's how the opinion read. I think Susan singling out parental consent is particularly relevant in the history of abortion cases, because the first big subject brought after Roe v. Wade was parental consent. There were two cases still in the 1970s in which the boundaries of Roe were laid out as it relates to parental consent, and parental consent was found to comply with Roe v. Wade. I agree with Susan that the language of this amendment forecloses parental consent. So that goes beyond Roe v. Wade, and I can obviously point to those cases, I want to say in 1976 and 79, that fleshed out those boundaries for parental consent. And those boundaries under Roe v. Wade were tighter with respect to keeping at least parents involved in children's abortion decisions than this amendment. The amendment rather clearly does not create exceptions. I should also note, well, let me finish the history. So you go forward, those are the 70s. You get to the Casey v. Planned Parenthood case in 1992, and the Supreme Court said it reaffirmed the central finding of Roe, that being that there was a constitutional right to abortion, but changed the test and sort of changed the legal landscape to say you couldn't burden a woman's choice in the first trimester or before a child was viable. It wasn't trimester. It was a switch from trimesters to viability. And then 30 years later was the Dobbs decision, which overruled Roe and found that this was a legislative decision to be made by Congress and the state legislatures, which is why our state legislature is taking advantage of that opportunity to try to advance a state constitutional amendment enshrining virtually universal access to abortion and probably taxpayer-funded abortion in the Virginia Constitution. So this isn't a statute, it's a constitution. When you see a federal constitutional case, the methodology used for interpretation is different than in states. I'll use statutes just by way of example. Federal courts, at least they're supposed to, interpret statutes under the U.S. Constitution in the manner that grants the federal government only those powers spelled out in the Constitution, the federal Constitution. In state constitutions, in Virginia's at least, the way the state constitution is perceived by the courts is the opposite. The General Assembly of Virginia has all powers that are not taken from it under the Virginia Constitution. I'm simplifying, hopefully not to a painful extent to an expert over here, but where the federal courts say the federal government only has those powers given to it by the Constitution, the state courts say that our General Assembly has all powers not explicitly restricted from it. So that's how this Constitution will be interpreted and applied by our state Supreme Court. This will not go to federal court. It is a state constitutional provision. It will be decided by, ultimately, our Virginia State Supreme Court. They will decide the meaning and when there are various fights over, does this fall under the amendment or doesn't it? They will not go to federal court. And where you may have seen in the news over the years when there are discussions of federal disputes, well, Senator X said this when they were passing the bill, and Representative Y said that. That's called legislative history. And it is, I'll say oftentimes, and by often I mean relative to states, but it is often used in federal courts when there's any question about what a provision of law means, to zero in on the actual meaning of the law. And in Virginia, we have almost no legislative history. In fact, Susan commented on what I believe is the only piece of legislative history that I'm familiar with respect to this amendment, and that is the amendment proposed in the Virginia Senate to explicitly ensure that parental consent would continue to be allowed and that transgender policies were not implicated by the amendment. And because that amendment was defeated, if the courts deem that there is some doubt about the meaning of the amendment, the only limited legislative history they have to look at to try to sharpen their conclusions is that rejected amendment. And they would naturally draw the conclusion that rejecting the amendment means those two items, parental consent and gender care, call it what you want, are included in the scope of this amendment, not excluded. So the answer to the question I was asked by this committee to talk about, does this amendment take us to a Roe v. Wade standard? The answer is no. It goes well beyond Roe in opening up and keeping open, for all purposes, abortion under virtually all circumstances. I would note that in at least two ways internally, the amendment is somewhat self-contradictory. First of all, it provides its own standard, something I would call super strict scrutiny. It defines compelling interest, state interest, in a manner that goes beyond what is normally the strictest standard in constitutional law, called strict scrutiny. It is an even higher standard to put any restrictions on abortion and potentially on transgender care as well under the language of the amendment itself. So, that goes well beyond Roe as well. And of course, Roe v. Wade never dealt with gender dysphoria or any policies flowing from that. So with that, I will leave it for discussion. Happy to answer questions as best I can. And, the chips will fall where they may when the votes take place on this. The reason there may be a rush, to put a political hat on for a moment, a rush to vote on these amendments, I say this amendment, but it's not the only one, the General Assembly will take up the session quickly, is that under the Virginia Constitution, 90 days must pass from the passage of the second passage of a constitutional amendment until the time when voters can vote on it. And of course, the point is so that voters can be informed about the amendment in enough time to make an informed decision. We don't normally have April elections, but there is an interest in the General Assembly to do this as quickly as possible, not for the abortion amendment, but because of the redistricting fights that are going all over the country. There is also a redistricting amendment, which we're not talking about tonight, but that redistricting amendment is why they're in a hurry. They want to put that in place as fast as possible so they can redraw the districts as quickly as possible for this year's even year midterm elections in federal elections. So there's when you hear about the potential for an April vote, that's why the April vote doesn't mean to do the amendment we're talking about tonight. But the fact of the matter is, whenever you get off general elections, you have lower turnout. And so a lower turnout of Virginians would decide the outcome of this particular amendment that we're talking about. So happy to answer any questions.
Thank you, Ken. Susan, you have a chance to reply to anything you might have heard from Ken that you want to discuss?
Oh, I think he did a great analysis. Thank you, Ken.
Great. Well, then I'm going to offer just a quick question in light of what I heard to both of you. Because each of you are discussing the difference between a Roe standard and this amendment standard. Could you take just a minute to reflect on the difference between a judicially created and judicially monitored standard based on something like due process versus a fixed language amendment which changes the judicial role to one of interpreting specific language rather than maybe having more flexibility to work with an evolving standard as we saw in the development from Roe to Dobbs? Is there a difference between constitutionalizing something with great specificity and otherwise, and I know there are a lot of people who are very upset about a judicially created standard, but in some ways, as a judicially created standard, one that changes the nature going forward in the future compared to a fixed standard. And that could be for people who are in favor of tweaking it around the edges on the advocate side for this amendment as much as tweaking it around the edges for those who oppose this amendment.
So that is a great question. And the fundamental, I'm going to kind of step back from my own views and everything else and just comment on one aspect of Roe, that as an idealistic lawyer who believes in the law, believes in the process of creating law that we have in this country, in that regard, the fundamental problem with Roe was that the court took on itself an extraordinary policy-making role that was completely inappropriate. When you hear people call courts super legislatures, it's because of cases like Roe v. Wade, where they step in and they decide themselves what the policy should be for the United States of America with no real language anywhere in the Constitution. And all Dobbs did, 50 years later, was say, that's not the role of courts. It's really all the Dobbs decision did. We're going to overturn Roe because this belongs in the province of legislatures. And this amendment we're talking about is it coming to us now. I hope it doesn't pass, but it's coming to us through a proper policy-making process coming through our General Assembly, which is the body in Virginia that's supposed to be making policy decisions, or at least proposals in the case of amendments, not courts. So it's at least coming through in the way I think the Founding Fathers anticipated our government working. Now, you asked a much more complicated question. When courts create standards, courts can change standards. When General Assemblies create standards, General Assemblies can change standards. And they're really the ones that are supposed to do that. And we, of course, put the people there we want with our votes. So, while I hope this amendment doesn't pass, it goes way, way beyond Roe in its pro-abortion positioning of the state government. It is at least not coming to us from a court, which I view as an improvement process-wise over Roe v. Wade. I don't know if Susan has other comments, but those are my thoughts.
But we have Susan responding to this first, and then I have some guidance for the whole audience for questions.
Yeah, I guess I would just point out that because they are looking for the exact language of the amendment, if a judge's hands will be often tied because it's so explicit, like the Commonwealth shall not penalize, prosecute, or otherwise take adverse action against any individual for aiding or assisting another individual in exercising such other individual's right to reproductive freedom. It is so explicit that it'll be hard for a judge to overlook this language, and they're going to have to rule accordingly in terms of the clear reading of the amendment.
All right, so we're going to open up to audience questions, and I was asked to give some guidance as to the ground rules for the audience questions, so I'll just mention those first. And that is that committee members are given priority to ask questions first. Guests can ask questions after, and there will be an opportunity, of course, for press to ask their questions as well. In addition, if you have a question, please raise your hand to be recognized, and I will recognize everyone from the audience, and then we have a mic that will move to them after that. Once recognized by me, please stand and state your name, stand if you can, and state your name and your city or magisterial district. And then please get to your question without a lengthy comment. In other words, we are asking for questions rather than comments. And then follow-up questions are okay, but we do want to move on to others, and please respect the idea that I've already seen far more hands than we might even get to. So to be respectful of your peers' time and keep your questions succinct. And so I will start. Go ahead with Les, or who was it here? Yes. So,
Jim Young, Potomac District. As a practitioner, I'm in Clover here. Thank you. Although my expertise is First Amendment, not state constitutional law. My question would be prefaced by the point that there is no law that's repealable except the law of unintended consequences. And while I haven't read the complete text of the proposed amendment, it sounds a lot to me like it would also cover the most fundamental reproductive decision, frequently forgotten by advocates for a liberal abortion regime, the decision as to engage in the activity which causes pregnancy, and that therefore the statute would virtually repeal every law of consent, the age of consent under current Virginia law. Would the panel care to comment on that?
So there are a number of areas of potentially unintended consequences. That is one. I would say, someone could interpret the question to take it all the way to things like sexual assault and so forth. And I don't think it will ever go there because each individual has their own rights under this, and one's doesn't trump another's. So, however, the age of consent falls under the reproductive freedom language that this amendment would remove from statutory coverage, by which I mean our current age of consent laws are likely eliminated under this amendment. That's one of the areas of potentially unintended consequence. Another is there will be an argument over requirements for taxpayer funds for abortion, and then the third is the transgender policy area are three areas where I think there could be unintended consequences.
next question. Yes.
My name is Tony Trefray from the Gainesville District. Generally, laws are being introduced here to solve a problem. For example, in the General Assembly does something about the speed laws, the driving laws. They're trying to save lives, solve a problem. Can you explain what problem this law is trying to solve? Because as I understand it, people in Virginia can still get abortions.
Yeah, and really, you know, our legislature is now in the control of the Democratic majority, both the House and Senate, and they are definitely a pro-abortion leadership. And so there is no threat at this point in time for any kind of law to pass that would overturn, would restrict abortion here in Virginia. There is no immediate threat. So there is no need for this.
I want to say something.
Go ahead.
I'm sorry, speak. I'm originally from New York, right? And I may be dating myself for a minute here. I may be the oldest person in the room. But back in the day, a lot of young ladies were having illegal abortions. And many of them lost their lives. And I work with seniors right now, and what I've noticed is that people with special needs can have sex. We're all adults in here, so we're going to talk about this. They can have sex. And some of them have gotten pregnant. No one can stop them. They get pregnant, and now, if they don't have any living parents, because a lot of their parents have aged and passed away, they're in group homes. And that's where they're doing this. Okay? I hear one side. I don't hear the other side. And I hear extremes on this. Unfortunately, I'm sad to hear that sex changes are included in this abortion bill. That's strange. But I also find it strange that a 10-year-old girl can come to school and be pregnant and no one brings it up, but they need to inform the parents. I don't think anyone should be getting an abortion without talking to the parents. But I also want to hold the parents accountable for a 10-year-old being pregnant or a person with special needs getting pregnant and no one's there to protect them. And I haven't heard anything addressing that.
So I'll start with the easier case of the young child. So we've talked about parental consent and so forth, so I won't revisit that. But the circumstances of a 10-year-old, to use your example, getting pregnant, could implicate Child Protective Services. So, and that exists across Virginia, the authority to address that. In my view, that's not eliminated by this amendment. However, I would say that 10-year-old is going to, that 10-year-old is going to have the individual rights under here that will eliminate, for example, statutory rape, as we call it. Statutory rape can be consensual, but where the girl is so young, you know, we set an age, different states have a different age, but we'll take 12 and under in Virginia. That is always rape in Virginia. Well, it won't be necessarily with this passage of this amendment. However, that doesn't mean that it's in the best interest of the child, and Child Protective Services can still have a role to play, particularly if the family is facilitating or allowing that to happen in any way. So let me jump to your tougher question, is special needs folks. I would point out that with technology today, special needs folks like Down's children, 90% of Down's children are aborted today. They're targeted for it. And, you know, the people make that decision. I wish they wouldn't, but then others, because of technology and improvements in health, they're outliving their parents, as you point out, and they are unable, in some instances, to care for themselves. And I do think that this amendment makes it harder, especially for those that are past 18, to put in place statutory restrictions that would help avoid the circumstances you're describing. I also worked 12 years in mental health commitment cases, which have some similarity to the circumstances you're describing. This is going to make that more difficult, and I actually think we're just coming in the next 5, 10, 15 years to a point where we're really going to see a significant number of parents who are going to pass away with special needs children at the extreme range that you describe, who didn't used to live this long. And as a society, we're going to be confronting that separately, and the particular circumstance you described is going to be a little more difficult to deal with this if this amendment passes.
Susan?
I just want to also touch on when you had mentioned that 90% of Down syndrome children are aborted. In Missouri, they had a statute that prohibited abortions if it was a diagnosis of Down syndrome or based on race or sex of the unborn child. And that was overturned. That was temporarily blocked. It's not enforced now because of the Missouri Constitutional Amendment. So that is an example of where this was a Missouri law, and then they went to court and they challenged it under the new Missouri Constitutional Amendment, and it was enjoined. It's going to have a trial this January to see if it will be permanently blocked, but it's very sad that a basic law like that, saying you cannot abort a baby because of the race or sex or the Down syndrome diagnosis, that was overturned by that constitutional amendment.
Denny?
Denny Doherty, Brentsville District. One of the areas of legislation that's come up through the years has been protecting the rights of conscience of those in the medical profession as to either individuals or institutions from being required to participate in something that violates their conscience. And I think there's been federal law on this subject. So my question is, what would be the effect of this amendment on that kind of statute? And related to it, what if the limitation is based in federal law, will the state constitution prohibit its enforcement?
So another great question. Thank you, Denny. Maybe we should bring Jim up here, First Amendment issues. But you will, what you've described is now first of all, I was about to say federal, but the Virginia Constitution has conscience protections based on religious belief, as you would find under the First Amendment. I'm not saying they're the same, but you do have a state constitutional basis to, for instance, if you're a nurse or a doctor, to at least make an argument under the state constitution that even if the individual presenting for an abortion has made a choice, that doesn't affect your ability to participate in. In fact, you might actually invoke this amendment. If I were your lawyer throwing in the kitchen sink, I would argue that your rights as an individual are to not participate in these particular activities, meaning abortion. And so it's gonna be used in both directions, I think. But that is a good example where you also have First Amendment religious protections, conscious protections that have been pretty well litigated. Not to say they never change, but those are pretty strong protections. So I don't know that this amendment will kind of provide a lever to force medical personnel to be involved in these procedures who do not want to be, beyond what the law provides and requires today. Susan disagrees, but I see.
Okay, so I can make some very valid points from the perspective of a doctor who has objections, moral objections or religious objections to performing abortions. But now I'm going to put on the hat of someone who is a proponent of this amendment. And they're going to say to the judge, well, Your Honor, the state only has a compelling interest in enacting legislation if it's to maintain or improve the health of an individual seeking care for an abortion. So they're going to say a religious objection to performing abortion has nothing to do with protecting the health of the woman who wants an abortion. So that state law has to go down. I'm just telling you that's what they will probably argue. And then, like Ken said, it'll be up to a judge to decide.
Here.
It's getting a little harder to get up these days.
Al Lawborn, Occoquan District. Question for you, Mr. Cuccinelli, which you're probably uniquely qualified to answer. When getting involved in public policy, which I did in the past life, one of the questions we always ask is, what happens if we do nothing? In other words, can you compare and contrast this with Virginia law as it stands today, and what protections exist or don't, and what does the world look like if Virginia doesn't pass this amendment?
And if I can just ask, if anyone is with the press, if you can also identify your press credentials.
Say again? I'm also a columnist with Inside Nova, for full disclosure.
Thank you.
Thanks for reminding me.
So, an excellent question, and I would say that there are policy areas where we require an analysis of what if you do nothing. In environmental impact statements, it's called the no-build option. What if you don't build? What happens, or what is the state of things? And Susan mentioned generally, in answer to the question about what problem is being solved, there isn't a threat to abortion access in Virginia today. I mean, it's as politically safe as it's ever been, and there's more abortion in Virginia, I believe, than we've ever had before. So without this amendment, we're still literally today at the peak of abortion in the history of the Commonwealth of Virginia right now today. Throughout the first and second trimesters, that's pretty much inviolable. The third trimester, there are restrictions. And this amendment has third trimester language, but I agree with Susan's comments about how the language has been written in ways that in other states have basically been a loophole that they have intentionally driven a truck through. Yeah, so I don't see any real restrictions here, pretty much up to the point of birth. And under current law, really the only major restrictions, one, are parental consent. Right? That's law in Virginia today still, and also third trimester abortion restrictions and partial birth abortion restriction. Just there are other laws, but that's the current state of play in Virginia if this doesn't pass.
There is one other provision, and that is the no taxpayer funding for abortion in Virginia. And we know in Michigan, they have filed suit under the Michigan constitutional amendment, saying that by restricting Medicaid abortions for women, it discriminates against women who want abortions, because you are helping women who want to carry to term but not paying for abortions. And under this constitutional amendment, it's very explicit. It says that the Commonwealth shall not discriminate in the protection or enforcement of this fundamental right. So that is what they've already filed in Michigan, and we will see how that case goes. But all the pro-abortion attorneys have to do is take that same case, the same filings, come to Virginia, change the wording, put Virginia instead of Michigan, and file suit. So it's in the crosshairs. We already know that by looking at Michigan.
Les?
Yeah, I'm a non-member, so I don't know if there's any other members that are. Anyway, I'll teach them.
Please go ahead. Here we go.
I'm Les Gabriel. I live down in Stafford now. My question goes back to something that both of you talked about, and that's the 90-day waiting period. And my question is, the Constitution obviously was written, I don't know, I think this provision goes back a long way, before the 45-day early voting started a couple years ago. So my question is, does the 90 days include the 45 days of early voting, or does it not?
So the 90-day waiting period he's referring to is not related to abortion. It is related to putting a proposed constitutional amendment before the voters of Virginia.
Right.
And there is not an established answer to your question, Les. The Attorney General in October, as it related to the redistricting amendment, opined that the election effectively begins 45 days before election day because it's open voting. Others dispute that, and it will undoubtedly be litigated if an attempt is made by the legislature to pass an amendment in January and actually have it voted on by the public in April. Now, if they pass it in January and it was voted on in June, then the issue you raised would be bypassed because there'd be 180 days total. 90 plus 45 is only 135 days. Sorry to do math on a weeknight with you all, but I was an engineer before I went to the dark side and went to law school. I love my numbers. So there wouldn't be an issue there. But if they are trying to run a vote in April, that will be a litigated issue. And I'm dealing with, ironically, a federal 27th Amendment case in which whether the election counts as the whole period where voting takes place or just the day it ends is also an issue. Now, my case isn't going to be decided in time to shed any light on Virginia, but with the recent explosion of states that have sort of created an election season instead of an election day, like Virginia has an election season, really. These questions are just now coming up because, not surprisingly, Virginia is not the only state with these kinds of time sequence requirements, but it hasn't been litigated anywhere that I know of yet. And God bless America, we may get to be first in something else here in Virginia. So
a quick question of clarification, since obviously your experience as Attorney General can answer this. What is the binding effect, if any, of an Attorney General opinion, such as that which occurred in October? And if not binding, must it be changed? And then lastly, if not binding, might it still have deferential influence on the courts, or do the courts only consider it just like any other persuasive piece of evidence?
So people in the political arena talk about it, who don't like it, talk about it like it's any other lawyer's opinion. It is not binding. It is, I would say, given not the level of precedential value that you would find, say, from an earlier court decision, but it is sort of a first among equals opinion by lawyers. I will tell you that, and judges don't ever say this, but in my view as Attorney General, and a former Attorney General, it was and is that the power of your opinions as an Attorney General really comes from how clear it is that you hew to the law. And I don't just mean in the one opinion at issue. I issued 400 opinions. And none of my opinions have ever been contradicted by a court. I'm the only living Attorney General who can say that. And the reason is that even when I didn't like the outcome, I stuck with what the law said. An easier way, I think, for a layman to think of what an Attorney General is supposed to be doing when they issue an opinion is giving their best reasoned view of what the Virginia Supreme Court would do if the question were litigated in front of the Virginia Supreme Court. And that's how I viewed my job, and that's how I answered those questions when I was Attorney General. But like I told you, if I'm the only living Attorney General who hasn't had a court contradict one of his opinions, that tells you that usually Attorneys General aren't as concerned, maybe as I was, with being idealistic lawyers issuing opinions that are legally correct, whether they like them or not. So that's the practical reality a lot of the time. So Attorney General Miare's opinion will be a starting point for a lot of the discussion, and he gathered together a lot of relevant legal authority, but it will not be anything like the final say.
Other questions?
Hi, I'm Sebastian Kraft. Hi there, I'm Sebastian Kraft, a reporter with Inside Nova. Just was wondering about if you could elaborate on the super strict scrutiny standard and kind of its implications vis-a-vis Roe and Dobbs and yeah, just moving forward.
So if you read the language of the proposed amendment, at the end, it actually writes into the amendment, and I'll read you the language, it's not very long, what it means by a compelling state interest, which is something that is pretty well understood in federal litigation. They're defining it here in a manner that is different. I'll read it to you. For the purposes of this section, meaning this section of the Constitution, a state interest is compelling only if it is for the limited purpose of maintaining or improving the health of an individual seeking care consistent with accepted clinical standards of care and evidence-based medicine, and does not infringe on that individual's autonomous decision-making. That final clause more or less swallows the rest of the standard. It's a little bit circular, but it's very clear that the individual decision-making authority trumps. Normally, compelling state interests are identified by the court. I mean, because strict scrutiny applies whether it's a Second Amendment case or a 14th Amendment case and so forth. They're defining their own standards here, and it is different than how I would ever read a strict scrutiny standard in an ordinary case, and it's, in my view, higher than you would find there. I don't know if you agree, Professor.
On that specific, I'm not saying, but I have a question. So, this is a very knowledgeable group, but there might be some people who don't know why scrutiny matters in the first place, and there might be people who don't necessarily know what the different tiers of scrutiny are. So, could you just give a brief tutorial about when does scrutiny matter, what does it apply to, and then also what is strict scrutiny versus other scrutinies, and why is this even higher than the other one? So basically, just take us back to Con Law 101 for a brief moment so to make sure everyone's on the same page.
Isn't there an entire class on this?
Yes. This is enticing everyone to enroll.
There you go. But so strict scrutiny is the highest level of standard traditionally applied by courts in constitutional analysis. And the compelling interest language, to get by strict scrutiny, a statute must advance a compelling state interest. Okay? The lowest level of scrutiny is called rational basis scrutiny. And rational basis means that the legislature could articulate a reason, a rational basis, for advancing the legislation. It doesn't have to be right. And the court doesn't have to agree with it. It just has to be defensively rational. There's intermediate scrutiny, named because it's in between the two levels of scrutiny. And the truth is, you look at Casey v. Planned Parenthood, they sort of came up with a new standard. So some courts will weave around within these standards and create new kind of subcategories, if you will. Usually, most statutes passed by a legislature get rational basis scrutiny, unless there is some fundamental right. That's language that is common in some constitutional law cases. Virginia's Property Rights Amendment passed with 76% of the vote in 2012, something I worked on for 8.5 years until we got it passed. Spoke to being a fundamental interest. And First Amendment rights, you see language along these lines frequently. Fundamental interests typically get strict scrutiny protection for the individual versus, say, the statute at issue. So we could go on in quite a bit of detail, but that the amount of scrutiny, the level of scrutiny depends on what I'll call the right or the subject at issue in the dispute.
And if I could just add briefly, strict, for practical purposes for the real people, non-lawyers in the crowd, strict scrutiny means the law usually is struck down. Rational basis means it's usually upheld.
Or as my friend Randy Barnett likes to call it, any conceivable basis review.
Yeah. Well, and if I may, that's why you see a big part of fights in constitutional law, not so much about what you think of as the merits of the case as a non-lawyer. They argue about what standard applies. Because as Jim Young just pointed out, the standard applied basically will determine the outcome in many, many cases.
Can I have a second?
Yes, up front.
Thank you. The compelling interest of the state raises this question in my mind. Therefore, I would like some consideration given, could this constitutional amendment be considered unconstitutional because it's taking away the right of the state to protect the unborn, which is, as I understand by watching television shows, the news, that there have been people convicted of committing murder by killing the fetus. So that's a human being, if that person is being convicted for murder, not just whatever. So therefore, yes, this may protect the rights of a woman to make a decision on anything she wants to do about her body, but the state also has a compelling interest into protecting everybody in the state.
So the history of abortion case law, in part, has been fleshing out the question of when does a compelling interest in the life of the child arise on behalf of the state? And that changed in Planned Parenthood v. Casey, for example, from Roe v. Wade. And then Dobbs didn't address it. Dobbs said, this isn't the business of courts. This is a policy question that belongs in legislatures, whether it's Congress or state. So that you obviously have two. I say obviously, we know things now that weren't known when Roe v. Wade was passed. That you have every bit of DNA and you are fully physically defined as a human being when you're conceived and then you grow. But where in that continuum do legal rights benefit that child and how? Those are policy questions that every state is answering differently. This is an attempt essentially to always leave the mother able to decide virtually any point in a pregnancy to end that pregnancy, and thus, so the child has no say, and under this would never have a compelling interest to its own benefit at any point in time, as I read the amendment.
Well, do you think it obviates the ability to charge somebody for murder for killing a fetus after this passes?
So, I think that you will, let's say we had a statute on the books today, and we may, that provides for a murder charge related to the child of a mother who is attacked. And that child is killed in that attack. Could a defendant defend by using this amendment? I do not think so, because the choice isn't the attackers, it's the mother's. And secondarily, the child's. And you would be defying logic, and I'm not suggesting you're suggesting this, but it would defy logic to allow a defendant assailant to be able to argue almost on behalf of that child for the benefits of this amendment, the autonomy aspect of the amendment, and thereby absolve the assailant of that killing. So I don't think there are what I think are probably unintended consequences that would roll out of this amendment if it became law. But I don't, like I said on the rape situation, I don't think that's one of them, and I don't think this is one of them.
So in Virginia law, then it's okay for someone else to kill the child in the womb without consequences, but not for another person to do the same thing.
I'm sorry, I'm not understanding your
Well, the
question.
mother chooses to have the child killed in an abortion. It's as plain as that,
Yeah.
killing the child. So this constitutional amendment says that person can't be charged with killing the baby.
Or anyone
But
who assists, who
someone
performs the
else,
abortion. Yes.
through another means, kills that child can still be charged.
Intervening crime.
Yeah, so the mother can make the choice, but someone else cannot.
Susan, your thoughts on this?
I agree. It's pretty clear. It protects the woman's right with her own voluntary consent. That's the whole purpose of the amendment, is the woman's right to choose.
Obviously, it's not protecting the child.
No.
Right.
Okay, thank you.
Other questions from the audience? Yes, over here. In the booth.
Is it on? I'm horrible. Me too. Hi, Becky Sheets, Coles District. I run the local Late First Pregnancy Centers. What is the outlook or the process for reversing this when this inevitably passes? What's the timeline? What's the process? What does it look like? How do you roll it back? Do you roll it back?
It's the same process done again. You can do a straight repeal, or we'll take the simple case of a straight repeal. To pass any constitutional amendment, including this one, the same exact language must be passed through both the House and the Senate of Virginia on one side of an election, and then again after that election is completed with the newly seated legislature, they have to pass the same language again, and after both houses have passed it again, there must be a 90-day period between final passage and voting on the amendment. Now this goes to Les's question earlier, well, okay, does that 90 days mean to election day, or does it mean to the start? We don't really have an answer to that question as of yet, and we'll see what the courts say on that. But that's how you would undo any constitutional amendment that wasn't liked. And in fact, I was talking about the timing being driven by the redistricting amendment. Well, that redistricting amendment is undoing a redistricting amendment. That's its purpose, is to undo the bipartisan redistricting amendment that passed, I want to say, in 2020 or 21, and to undo it at least for a 5-year period. So that's what's going on there.
If I can ask a follow-up on that, other than the 90-day issue, are there any, and to follow up on what other challenges might come, are there any process challenges that you anticipate or see possible to try to invalidate?
I see one other, and that is there is a statute that requires 90-day notice. It mirrors the time period in the Constitution, but it requires your circuit court clerk to post proposed amendments at the courthouse 90 days before an election as well. Again, a statutory requirement that mirrors the constitutional requirement. It'll be thrown in as they'll both have the same outcome, but it will be another claim that lawyers will include in those cases. So that's what I would expect.
Susan, do you expect any?
No, I agree with that.
Other questions from the audience?
If I could just flesh that out just one teeny bit more, just to clarify. There are no federal, legal, or constitutional issues with passing this amendment, in my view. This is the business of the people of Virginia. Now, I don't want it to pass, but this is our business, collectively, all of us here in Virginia. And it doesn't violate any federal constitutional provisions. Under the Dobbs decision, the Supreme Court said, look, this is the business of states, not courts. So it's up to us.
Can I ask a question? While people think, in case people have additional questions, are other states working to enact amendments that do the opposite of this?
Well, like Missouri right now, they are doing what this woman suggested. They have a new constitutional amendment to try to reverse what the pro-abortion constitutional amendment did. And that's going to be in the November election. So, but like Ken said, here in Virginia, it's quite a process. You'd have to, first of all, get a pro-life majority in the House of Delegates, a pro-life majority in the Senate. Then you'd have to have the money to be able to get the word out to the people of what, you're really doing with your constitutional amendment. And the other side will have a lot of money giving their perspective. So it's quite a process to try to reverse once these constitutional amendments are enacted. So the real thing that we have to do is try to educate people now about what this constitutional amendment is all about, to try to stop it before it becomes enacted.
I would note also in Wyoming, I want to say in the last week or so, their Supreme Court ruled that abortion protections, meaning protections from abortion, were outlawed, were illegal under a 2012 health care amendment to their constitution. So the people who wanted more abortion came and argued abortion is health care. That was the central legal argument of the case. And once it was decided, yes, it's health care, it's a form of health care, then the 2012 amendment, which they had never intended to cover abortion, was found to bar the legislature from providing certain protections. So now they're just beginning to publicly discuss the very process Susan described of passing an amendment in Wyoming to remove abortion from their healthcare freedom amendment that they passed 13, 14 years ago.
We do still have a few minutes available if anyone has questions. Yes, in the back.
So I live in Fairfax County.
And your name, please?
My name is Shelley Arnoldi. I live in Fairfax County, the Alexandria portion. My children were in middle school and high school in 2020 when COVID started, so I'm very new to all of this. So I've been trying to get involved in parent groups, wake up parents, and it seems like the only people that are even getting involved don't have kids anywhere near school. And I want to wake up my neighbors. I have to drive an hour to get here. No one seems to be doing this. Like, I don't even have a question. I just have a statement, like how far I have to drive to hear what you have to say is so important. And I can't get this to my neighbors. And I don't know how to do it. So I would ask that when they asked about what you could do to reverse, maybe write the bill, get at least one person to get it out there so that eventually when people catch on to social media, guys got to use social media, then they can use it, because all the money is controlling our elections, but social media is controlling what people do. Sorry guys, boomers, Gen Xers, me too, we have to wake up and do things differently. As awesome as this is, there's way too many people in Northern Virginia that don't have a clue what's going on.
Yeah. So one unique thing I have found, I've lived in Virginia my whole adult life, but I've operated nationally. don't take this the wrong way, I'm in this bucket too. We're not normal. And by that I mean, Washington, D.C. is our backyard. And so national news is sort of our metro section. And that's just not true for most of America. And it's worse, you know, there's the saying, telling Nova and Rova, Northern Virginia and rest of Virginia. And certainly in Nova, the Washington focus makes it really hard to penetrate for state level discussions. Take it from a guy who ran 3 times for Senate in Fairfax. I managed to win once in a recount, but I can't tell you how many doors I knocked on, and they thought I was talking to them about running for the U.S. Senate. I said, no, I'm just running for the state Senate. And it took a fair bit of explanation that doesn't happen if you're not literally on their doorstep. And I also would tell you that more people told me, gee, you're the first candidate I've ever met, and because it isn't normal. So see, I'm not normal. And it is very hard to penetrate. Susan made the point earlier, the practical reality about repealing or limiting an amendment, and she mentioned money, just like you did. And money isn't about buying votes. Money is about being able to present your case in a way that people can see it. And that is hard, and it is expensive, and penetrating into Northern Virginia in particular is more difficult than anywhere else in Virginia, which means it costs more money. So, you know, you advance an amendment like this, and each side's going to try to make its simplest argument, because the longer your argument, the more money you need. And you can predict what both sides of this amendment will say, but it's really going to be decided by who shows up, especially if it's an April vote. You'll literally have maybe 25% of Virginians deciding on this very important amendment, and maybe another one as well. So actually, if we're deciding on this one, we're also deciding on the other one. The other one's the reason for the hurry, you'll recall. So I wish there were a simpler way. I am glad we're not inundated with these every year. Amendments are not as common in Virginia as they are, say, out west, where you have initiative and referendum. And while I can appreciate citizen initiatives, you can also end up with so many things on the ballot that talking about any of them waters down all of them. And we don't really have that issue in Virginia. It'll actually be very rare to have 2 amendments on the ballot at the same time. That alone is, I don't remember that happening before, and I've been paying some sort of attention for about 35 years. So, speaking of aging myself.
Susan, any thoughts on how you get the message out?
You know, I was just thinking about your question. You know, it's really amazing how, you know, people think, what can I do on one person? And it's really, you know, it's funny, like with the legislator, and Ken, you were a legislator, maybe you can speak to this, but people, you never know what's going to resonate with the legislator. You just never know what you might say that will resonate. If you go to a town hall meeting, if you show up at the legislator's office, if you invited people like myself to your church to talk about this amendment, or if you're involved with any other groups, you know, you can do as one person. There is a lot you can do that you don't even think will make a difference. Like I know people will say, oh, what's the point of calling my legislator? You know, what's the point? You have no idea. There's a saying, when they feel the heat, they see the light. When they get swamped with phone calls or emails, then they go, oh, people are really paying attention to this, okay? You know, it's just the reality of politics. And so your one little call or email, it becomes a whole mass that adds up to swaying people. You know, some people like Ken, they are there because they are standing on certain principles. Some people want to get reelected, and they're the people who really pay attention to the calls and the emails.
I will tell you one quick pre-email war story, and it's from Vince Callahan, who was the longest serving delegate when he retired, 44 years. Vince Callahan was, he was sort of the Frank Wolf of the Virginia General Assembly, and he was asked in a town hall meeting, now this is around the year 2000 or so, Delegate Callahan, how many constituents do you have to, how many letters, it was asked about letters, that tells you when it was, right? How many letters do you need to receive on a bill to really pay attention to that? He thought about it. He said, 5. Yeah, that was about the reaction. They were like waiting for the second digit. 5. And I was, as Susan noted, I was in the state Senate. I got there in 2002, so email was just kind of growing as a communication means. I certainly used it. When your own constituent calls your office live, that is a rare occurrence. It is a rare occurrence. And you should not simply assume because of R's and D's that everything is already decided. Sometimes it's pretty well baked in, and there's more of that these days than there used to be. But your job, your duty, your opportunity as a citizen is to petition your government. You've heard that phrase, and that's how you do it. It's much more important that you call your representative than that you call, a bunch of others. Now, there's a place for both of them, and, we can be very tactical about it. If Fred Smith wants to run for Congress, Fred Smith might pay a little bit of attention to what people think about Bill X outside of his usual district. If Fred Smith wants to run for the Senate, he might pay attention to people anywhere in Virginia. So you do get that personal dynamic with some legislators at various times. But Vince Callahan, I have told that Vince Callahan story I don't know how many times because it is so powerful. I was a state senator. I can tell you the number's not exactly the same because of email, but it's so true. There's no one more important to these elected officials than their own constituents.
If I can add one thing, and that is, I would encourage people, if you encourage people to have these conversations in multiple areas, I would encourage them to also follow the model of the Prince WilliamCommittee of 100, and that is to invite multiple perspectives, which will grow the audience, which will grow the conversation, which will test ideas in the marketplace of ideas. And so I commend the committee for doing that, and then encourage people to accept those invitations so that there is that robust conversation. And encourage those of your friends who might disagree with you to encourage those who are leaders in the opposition to also accept those invitations, because it adds to the conversation.
I would also add, I would rather have a civil discussion with people who disagree with me than no discussion. And we also need to be able to model it in this day and age. I mean, you look at what happened in Minnesota this week, and I don't want to get into all of the politics, but instead of calming people down, a lot of elected officials are firing people up. That's not a one-sided affair. I have my own views about that, but how do you bring civility to public discourse? You practice civility in public discourse, and there are a lot of us that are happy to do that. There are many people who aren't, and I worry about those people. They're kind of a threat on all sides. But, I appreciate the invitation. I appreciate the attempt to have all perspectives here, and I tried to present a little bit of what the other side would say. I heard Susan do the same, and I appreciate that. But I feel very strongly about that. And this is a guy who goes on I'm right of center, obviously, and I go on CNN, and I go on Newsmax, and I go on News Nation, and so I'll talk to all these folks.
Then you should join Committee 100.
But, you know what? If it takes you 2 hours to get here every then, I'm sorry.
Do televise it.
Well, I'm being told that we are at our time. I want to thank our panelists for their presentation. And I will turn it over to Lynn for our final comments.
Thank you. I want to just give another round of applause to our panelists and our moderators. Thank you so much. And I'd like to also just acknowledge that we had a lot of our members do the work of this committee to get this program to this place and for it to be as successful as it is. I won't say their names in case they don't want everyone to know, but I want you to know that this committee was started well before me, and I cannot take credit for the history and the success of this committee. It has been put on the shoulders of those who came before me, and our committee is well known for our balanced programs. And the fact that we were unable to have all panelists attend due to scheduling was something that we were not thrilled with, but we do believe our mission is to bring information to our residents and the voters, and that has been what we've done tonight. And I think it has been an amazing program. Thank you for all your questions. I want to take this opportunity to pass the baton to Retta Young, who is going to talk about membership really quickly, and she'll close our program. You don't have to rush out, but I hope you'll say goodbye and make some networking, and I'll reach out to each of you who came this evening. Thank you. Retta?
Thank you. Is it on? Okay, good. Real quickly, first, thank you so much, speakers. You guys did an amazing job. By a show of hands, how many of you in here are actual members of C100? Great. All right, thank you. And those who are not members, raise your hand. I want to give out brochures. Awesome. Before you leave, just in case you decide to come down for 2 hours drive, to visit us. I want to give out these brochures for those who are not members. And also just to let you know that as a member of C100, we do these monthly meetings. We have great conversations. Last season, we talked about DOGE, the impact of it. In the Packed House, we talked about the data centers. And we continue to have great conversations like this that really impact our community. And so with that, I hope you take this information. Please find out more about us. Go to our website, PWC 100, to join. And also come out to our membership drive next month. If you didn't get a brochure, please take it. Thank you so much.